everybody. Welcome back. Shout out to everybody in the chat. Okay, so we definitely have a lot to cover and we got to get started right away. Shout out to everybody. Let me make sure that I share this, guys. Do me a favor and hit the like button. All right, hold up. Sorry, I'm hearing myself. I have multiple screens and I'm hearing myself everywhere, and I don't like that. Let me share this with everybody. I don't even think I shared it with Discord for those that don't get notifications. We live now. Shout out to everybody, guys. Thank you so much for being here. There's a couple things that I want to start with. First of all, we got the first and second day of transcripts for the U.S. Sean Combs versus, the U.S. versus Sean Combs Diddy trial. Shout out to everybody that donated with the Cash App or Venmo, or I just put up the PayPal on the Discord. I'll put it on the community wall. PayPal isn't something that I use often, but I definitely need to start using it more. It's just too many damn pay links to, remember and stuff like that. But I appreciate everybody that donated. So we're going to receive the transcripts for the first week of the trial, right? So I'm trying to understand how to best go about this. I already have the first day. And I figured, all right, I'm going to record this. We're going to finish and recap a little bit about what happened today, because I still need to finish about what happened today. I usually end my lives in the 4-hour mark or something like that, 4 or 5-hour mark, depending on what I have to do, because I have to pick up my youngest son or my middle child. Excuse me. I have to pick up my middle child and then log off and then go about my business. So I have to kind of do that, come back, finish that up, and then whatever time we have left, we're going to start reading the transcripts for the day one, the opening statements, okay? And then what I'm going to do is use this opening statements and make it into a pre-recorded to continue whatever we don't finish. Day one opening statements is about, what was the page number? Hold up, let me just double check the page number on that. What did we say? 246 pages. So you guys have to understand that this is going to be multitude videos. Now, why these transcripts are very, very important is because you're getting information that the journalists in the room, Inner City Press, all of them, shout out to them, by the way, they're not getting this information. They're literally not getting there's certain aspects of this info that they're not getting. Now, of course, there's things that are redacted and are, blocked for privacy and, covering up people. That's fine. That's there. But these are court reporters that their only job is to report what people are saying, what the professionals are saying in the court. So if you have not watched this trial and you're like, where do I start? I'm thinking that the best way to do this is to do the pre-recorded and then drop them. Drop them basically this weekend, depending on how much time I have to record and everything. So keep that in mind. But we got our feet and we ready to go. We're going to do that. I'm excited that we at least have day one, day two, day three is today. So we should receive day three by tonight. Day four, we receive them at the end of the night, the conclusion of the hearing. And then of course, we'll resume. Right now, we're only talking about the first week. We're not talking about the next week. We don't know what's going to happen. I definitely don't think that, $1,312 is a lot of money for transcripts. Okay. So just so people are aware. Okay. Let's get it together, guys. Hit the like button, please, and thank you. Yes. Okay, so I want to start by finishing up where I last left off, just so I'm up to date. And that's what we're going to do. Do me a favor, guys. Please hit the like. Thank you. And welcome, everybody. Welcome. Okay, I think it's good enough time for us to get started, because there's so much to cover right now, especially with day one opening statements. All right, so we left off at the break, and around before the break, Cassie was talking about how her mother in Connecticut knew about some bruises. She wasn't being entirely honest with her mom. So there's that. There's a lot in between here that Cassie seemed to have, at the very least, have been concealing from her parents. Like, she wasn't sharing with their parents that there were freak offs. She wasn't saying things like that. I mean, clearly she was guarded, okay? But let's get it together. That's kind of where we left off, okay? So they do a little break, and about 3:09 p.m. Eastern time, Inner City Press writes, they're back. Judge says, Miss Johnson, any estimates? The government responds, an hour more. The goal is to finish the direct and allow the start of cross-examination today. The judge then says, bring the witness and then bring the jury back in. The jury enters. Okay. And then this is when everybody all rise, right? Because they have to rise up when the jury goes in. Government then says or asks Cassie, did anyone come to see you in Connecticut? Cassie responds, Scott. Scott did. For a few days, I broke it off with him. It was too dangerous. Objection. Okay. So for those that don't know who Scott is Kid Cudi. Okay. Scott is Kid Cudi. For those that don't know. All right. So she's like, I broke it off with him. Defense gets up and says, objection. Judge says, overruled. Sean said he would hurt us both. This is what Cassie said. Where did you go after Connecticut? I went to see Sean. He was in Arizona, his son, college. I told my mother I was going to LA for work. Did Sean talk to Scott's? Excuse me. Did Sean talk? And I believe he meant to say, did Sean talk to you about Scott's car? Sean said he wanted Scott's friends to see Scott's car blown up. Government asked what happened next. We met Sean, Scott, and me. Scott said, what about my vehicle? Sean said, what vehicle? And that was the end of that meeting. Government then puts up a photo. Government puts up a photo and then asks, what is this? Cassie says, me and Sean in Kingston, Jamaica for a sound clash. Government asks, were you bruised? Yes, Cassie answers. And this photo, what is it? Me in Sean's bathroom, September 18th, 2015. What were you doing in there? Cassie responds, recuperating from being beaten up by Sean in Las Vegas. We were having we were having an after party in our suite. I don't know why the word third came in there. We were having an after party in our suite. I talked to a producer and Sean tapped me on the shoulder, called me into his room and beat me, kicked me as I tried to hide behind the toilet. What stopped it? Cassie responded, D-Rock and James Cruz came in. It made D-Rock sad. Okay. D-Rock is Diddy's bodyguard. Okay. What are these communications the government is asking? From D-Rock to me, he says, where you at? It's time to ice your face. Government asked, why? I had just beaten up by Sean. So I guess they were like in an icing schedule. Like that's weird, but that's kind of what was going on. Like, okay. Let's keep going. All right. Were these all the times he beat you? No, there were more. Government asked, with who else did you see Sean be violent? I saw him drag an assistant out of bed. I saw him punch Eli or Ellie. I think it's Eli or Ellie in his head. One time in Caicos, he dragged a person. So I saw him drag an assistant out of bed. Then I saw him punch Eli or Ellie or Ely in his head. So one time in Turks and Caicos, he dragged a person. I believe he had a freak off. Excuse me, hold up. I believe we had a freak off in Turks and Caicos. What floor did you live on? What floor did you live on in 875 Comstock? The 17th floor. Did a friend stay with you? Yes, Sean. Yes, Sean came and held her and threw her on the patio furniture out on the balcony. This is the designer that filed that lawsuit, by the way. For those that don't know, this is the designer that did that. There was a designer that Diddy was working with, and Diddy, this is what's being alleged. It's been said. Diddy came over to this apartment. Something was going on. If I remember the lawsuit correctly, I think he had been drugged or something to that effect. Okay. And basically got angry with her, threw furniture at her or threw up against the furniture, and then held her from like 17 floors, which is where Cassie was staying. That's crazy. She was a designer. She's well known. I forgot her name, but I think is it Bama? I think it's Bama. Anyways, correct me in the chat if I'm wrong, but let's keep going, okay? Whew. I saw Sean bring her back in front. Excuse me. I saw Sean bring her from over the balcony, then throw her on the patio furniture. And Carrie Morgan, I saw Sean hit her in the head. Did you get drugs on your own? Occasional drug dealers, opioids, Xanax, and Valium. Sean would put the pills in a vitamin C bottle on the sink in the New York apartment. He'd say, "You can take him." I think he meant to put in here, "You can take them." He had doctors who would write the scripts in the same name of an assistant or my name. This is very common. This is a very common thing. So if anybody remembers the R. Kelly case, R. Kelly had a doctor who was let me not misspeak, but if I remember correctly, he was giving him like penicillin shots or something like that, because he was getting all kinds of diseases and stuff like that. So he actually testified in court, and I remember this because I think I talked about it on my channel when this happened. So that was a thing. If anybody remembers the R. Kelly trial, let me know if you remember the time that the doctor testified in R. Kelly's case that he was injecting R. Kelly and treating him for STIs and stuff like that. So this is this is like Michael Jackson. Michael Jackson had a doctor. We know how that ended. This is a thing. There are celebrity doctors that make house calls specifically. Dr. Charles Sophie is one of them too. For those that don't know, the psychiatrist, Hollywood psychiatrist. Okay. Guys, do me a favor, hit the like button, please, and thank you. Yeah, that doctor put R. Kelly on blast. Some of you guys remember that. Okay. So he had doctors who would write the scripts in the names of an assistant or my name. Your brother's birthday is what the government is asking. Your brother's birthday in Connecticut in 2013. What happened? My mother told me someone was taking pictures of me. I went and punched her in the head. My mother told me someone was taking pictures of me. I went and punched her in the head. That's what she responded. You testified your relationship with Sean ended in 2018. How was your health? Okay, stops right there. This is why the transcripts are very important, because of the simple fact that the transcripts are going to fill in what we're missing here, like things that just didn't get captured from inner city press or other people in the court. Okay. You said she punched the person taking the photos, taking photos in the head. So that Cassie punched somebody in the head taking photos of her? Is that correct, Christine? Let me know, okay? The government asked, you testified your relationship with Sean ended in 2018. How was your health? Cassie responds, I was sleepwalking. I had PTSD. Defense response, objection. Government then asked, what's this? Ventura says a photo of my front door in 2018. Ooh, sorry, y'all. I got coffee in here. Government says, publish it to the jury. Why is there a knife there? Ventura responds, Sean was coming around a lot, so I had it. Government then asked, what happened? Government asked, August 2018, what happened? Cassie responds, we were having a closure conversation at a restaurant in Malibu. He was trying to convince me to go to Burning Man. Were you seeing anyone? Cassie responds, my now husband. What happened next? Government asked. Sean came to my house and arred me on my living room floor. His eyes were black. It was like talking. I think he meant to put talking. It was like talking or taking something from you. Excuse me. It was like taking something from you. Sean came to my house and arred me in my living room floor. His eyes were black. It was like taking something from you. You cried? What did Sean do? He continued and finished inside of me. Then he got up and left. Did you ever have sex with him again? Yes, voluntarily. We had a good night. I went back to his house. Can you explain why you did that after he arred you? We had been together for 10 years. Okay. This is definitely triggering, so keep that in mind, please. Who did you stay in touch with? Cassie responds, most people, though I pulled away. What did you message Sean after that? Cassie says, just checking in. Government asks, what did he send you? Cassie says that he had iPads full of images. Get him his money. Money back for what? For having paid my now husband to be my trainer. What did you write back? Do you want me to tell the truth? It's much deeper than iPads. There was abuse, more than freak offs. There was a time I couldn't take the pain, tried to walk out in traffic. My husband wouldn't let me. I had trauma therapy. Did you write? A book with chapters. My mom helped. What did you want? What did you want with the book? That Sean read it. What pain did Sean put you through? Shame. To carry the things that were shameful for him. I took on a lot of responsibility for that. I never should have. He brought the concept to me when I was 22. It was expected of me. I felt terrible. How did you get chapters? How did you get chapters to Sean? I think they're referencing the book. Okay. Through my attorney, and I reached out to KK. I asked her if he read it. She said it was not taken seriously. How much did you ask for the book? All right, let me pause right here real quick. For those that don't know, Cassie, Cassie was threatening to write a book. Okay, so there was a lot of speculation when the lawsuit kind of dropped that the reason why Cassie did this book is because Sean didn't want to pay her money so that she could write the book or something like that. So this is where the book is coming from, right? There was this, and then the lawsuit followed shortly after that, if that makes sense, right? So she says, she said that it was not taken seriously. This is what Cassie answered. How much did you ask for the book? 30 million. Did you sue? November of 2023, Cassie responds. What happened with the lawsuit? It settled for 20 million in 24 hours. We didn't even know the settlement up until now. Now we know how much that settled. Did you guys remember? Undisclosed amount. Well, I remember I was up that night because I didn't expect to report the following day on this settled lawsuit. I remember that. It settled for 20 million in 24 hours. Why are you testifying in this trial? I can't carry this anymore. What's wrong is wrong. I tried people like they were disposable. Escorts, anybody. Okay. It's probably a typo or misprint there. Government asks, how many freak offs did you have with Sean? Impossible to know. Hundreds. After you broke up with Sean, did you ever do a freak off? No. Government then says no further questions. Wow. So that is where government stops, okay? Okay, there's a sidebar that happens. This is what the government says. Sidebar before cross. Judge says yes. Okay, so then there's like I guess a little bit of a break here. All right. He writes, Inner City Press, with jury out, judge then says, why don't we put off the cross until tomorrow? Government gets up and says, we'd like to start now to be sure to finish. Judge then looks at the defense. Miss Estavo is Combs' attorney. She will be finished by the end of the week. Judge then says, so no cross today? All right. So the judge then says, we'll just make up the time in other ways. Get the jury. The witness can be excused. This is what the government is asking. Judge responds, yes. Jury is entering. The judge then says, sorry to bring you out only to send you home. Don't read anything about this case. Have a great evening. All rise. Okay, the jury is exiting. The government, the judge then directs a question to the government. Ms. Comey? Government responds, here's what the defense sent us about Rule 412. We believe we had agreed that other sexual acts by the witnesses were not admissible, but we understand they intend to cross-examine her about other relationships with texts about sex, about Miss Ventura effing someone else. Why is that necessary? I don't want to read these into the record, so I'll hand copies up. Defense, the judge is asking. Agnifilo response, these are messages about jealousy. In the vocabulary of, are you effing that person? That's fair game. This is the real world way people express hurt. Agnifilo. Ag fucking nifilo. That's gonna be my new word tomorrow. Ag fucking nifilo. Okay. I got a lot in my head right now, but that's gonna be I gotta get Diddy's clip for tomorrow. Hold on. Diddy's clip. And agnifilo is not agnifilo. It's ad fucking nifilo. I love it. You love it. I love it too. You gotta. He's like, he is tripping. All right, let me move on. Okay. Oh man. Judge then says we could do it in the is it robing room? The government responds the defense would have to be present. Judge then says so in the courtroom sealed. Government responds counsel for victim 1 would like to be heard. The judge then says I see his hand. Mr. Wigdor. Wigdor then says we are entitled to notice. Okay. So then judge says, so tomorrow morning, adjourn. Okay. So this is where it ends. Okay. Literally, shout out to Inner City Press. He is literally a machine to be tweeting every step of the way. All right. Shout out to Inner City Press. Okay. Now we're going to switch over. All right. We have to switch over. Let me see. Where are my screens at? Where am I? I'm like away from here. Why is Bigfoot trending? That is a fantastic question. I'd like to know. Everything's weird. Is it really trending? Was it there? Oh my God, you're right. It is trending. On my Twitter, it says that Bigfoot is trending. I don't know why. I don't know why. Hold up. Now, let me let everybody know we live now. Okay, for those, let me tag people here. Oh, I didn't even share it. Everyone, we live now reading day 1 of opening statements. I don't know if everybody got notified. Day 1 of opening statements. Okay, so for those that are coming in now, who's looking for me? Bigfoot is looking for me? Okay, probably. I'm in court. Y'all see, I'm outside. You see this busy street? I am right there. I'm right over there, somewhere over there, but next to that camera with the guy with the glasses. Okay, let me stop sharing this. Let's get into this. Share screen. Here it is. All right. Shout out to Danny Robertson. Of course, this is her watermark for those that don't know. Danny Robertson, make sure you guys check her out. You guys know Danny Robertson is a friend of mine. She's amazing. And the reason I'm able to read a little bit of this is because of her. Shout out to her. All right. So this is how we're going to do this. Because like I said, this is 246 pages. So as much time as I have, we're going to read the opening. I'm going to edit this part out and add it to the video to continue the conclusion of the opening. Okay. So let's get it together. I won't be watching the chat too much, but do me a favor and hit that like button. I would really appreciate it. Okay. All right, so here are the official transcripts for the court. Started at May 12th at 9:18 a.m. They entered their appearances, okay? And everybody's present. Agnifilo, all the attorneys, all of them. Hold on, maybe we should read. For the United States, Madison Sminer, Emily Johnson, Maureen Comey, Meredith Foster, Mitzi Steiner, Mary Slavic, okay? For the defense, Agnifilo, Mark Agnifilo, Tini Garagos, Sher Tremont, Anna Estevallo, and Alexandra Shapiro, Jason Discol, Xavier Donaldson, Brian Steele. So that is a total for Diddy's got 1, 2, let's see, 3, 4, 5, 6, 7, 8 attorneys total. They're on the record. Okay. Also present is Linda Moreno, defense jury consultant. So they hired a consultant for the defense, just so everybody's aware. All right. They're in the robing room. Okay. This is where it starts. This is Mr. Agnifilo. Listen to what he says. One thing on the record, the court's record, I'm happy to do it on the record. I'm going to ask that victim number 1, when she testifies, be already in the jury box when the jury comes in. Only asked to her, only because of her physical condition. I mean, there are certain things we can't control about a juror who is 8.5 months pregnant. But I think there is a quality to her walking in front of the jury that I think is easily avoidable. I'm not making an application for any of the other witnesses. The court, who is the judge, says, wait, let me make sure I understand. Agnifilo responds, yes. Miss Comey, who is the government? Miss Comey, who is your first witness? Miss Comey responds, first witness is Israel Flores. Okay. The court responds, that's what I thought. When did we get to the third witness, which is Miss Ventura? Okay. No, this is important to note. Okay. Miss Comey responds, correct, Your Honor. The court then says, when we get to our third witness, just for purposes of that witness, Agnifilo says yes. The court then says, you would like her to be already sitting in the witness box? Agnifilo responds, yes. Court then says, when the jury comes in? Agnifilo responds, correct. The court then says, all right, let me think about that. Miss Comey then says, Your Honor, we would object. If Your Honor is considering it, I would like to be heard on that. I don't think there's any basis to treat any witness differently because of a medical condition, most notably pregnancy. I think that would be deeply inappropriate. Mr. Agnifilo jumps in. I can make the application. It doesn't have to be done now. It can be done before she testifies. Anytime good for the court? The court responds, I'll think about it. Miss Comey makes the point. We wouldn't treat people differently based on any other sorts of medical conditions or physical impairment or any other attribute, right? Why would we treat this differently? Agnifilo responds, because I think there is a prejudicial quality. Pregnancy is beautiful and wonderful. It also is a source of potential sympathy. Agnifilo didn't want her up there. Do y'all see that? This is why the transcripts are so important. Do y'all see that? Agnifilo did not want a pregnant Cassie walking along. He wanted her to be sitting before the jury got there. Y'all see, this is why the transcripts are very important. This is stuff that other people, journalists, are not catching. Y'all catch it? Let me know. Okay, I don't know why I brought the rabbit. It's a cute rabbit. Okay, great. I'm gonna have to edit this out. Baby K44, thank you so much for the 199, my love. Shout out to you. Thank you. Thank you, baby K. I appreciate it. You got that? You got that. All right. Yes, we about to get every ugly court detail. Okay. Just this is why they're important. You said this is why I said, what did I say? What did I call him? I forgot. What did I say? Agnifa fucking do something. I forgot how I put the F word in his name. Y'all help me in the chat. I forgot how I did it. I really did forget how I did it. She was so for those that were saying that she was going to be due that week, no, she's 8.5 months pregnant. Cassie is 8.5 months pregnant. People were guessing her pregnancy. It's on the transcripts. Well, at least this is what Agnifilo says. I'll put that out there. We don't know if she's actually pregnant, okay? But that's what she says. That Ellen, thank you for being here. Thank you. Didi's laughing. I forgot what I said. I have to listen to this recording. I can't remember how I put the F word on Agnifilo's name, but I put it in there. All right. Okay, so Agnifilo says, because I think there's a prejudicial quality, pregnancy is beautiful and wonderful. It also is a source of potential sympathy. The court responds, they're going to see the witness. Agnifilo says, 100%. The court then says, aren't they also going to see the witness leaving the stand? What are you trying to achieve? Agnifilo says, well, so in past trials, and each trial is different, I've certainly had situations where the jury was excused before the witness either sat or left the witness stand. And I would make that application for all the witnesses, except I think it makes a certain except I think it makes, except I think it takes a certain little bit more time. So I wasn't going to do that in the interest of time. I've always preferred the procedure where the witness is seated when then the jury comes in. I've probably had most of my trials with that as the process. The court then says, well, the court does that too when it fosters efficiency. I'm sure we will actually do that at this trial. But you're making a different application. You're saying we will, in fact, have the witness seated whenever the jury comes in, and there's an objection to that. And it's a fair one that I don't know that there is any support anywhere in the history of American jurisprudence. You can find that for me. You can find that for me. You've got time. I've heard the objection. I tend to agree with it. However, you've got until the afternoon because this isn't going to happen. If it happens today at all, I think you've got some time. If you have any support for that, I'm happy to take a look at it. Okay, so the judge is saying, like, listen, it doesn't happen anywhere, but if it does happen or if it might, I don't know. But if we have time, we'll look at it. And I'm sure you got plenty of people there that could probably help you with that, right? One way or another. This is crazy, yo. He said, Rabbit, you're going to turn 10 shades of red reading. Literally. I cannot. They didn't want us, the defense didn't want people to see her pregnant because they felt like it was sympathy. What do you guys think about that? Let me know. All right, the deputy clerk. Your Honor, can we go off the record? Okay, they're in recess. Now it's open court. The court, which is I believe the judge. Mr. Courtroom Deputy, are we prepared to proceed? The deputy clerk answers, yes, Your Honor. I will check on them right now. Ms. Shapiro has something to say. Your Honor, I'm sorry. Can I just put one thing on the record? The court responds, yes. Ms. Shapiro says, we just want to note to supplement the Batson application, which we understand Your Honor has denied, that in addition to the points Mr. Agnifilo made, that two of the Black individuals the government struck, number 161 and 163, were the only two Black men in the first 28. This is a huge deal when we talked about it earlier in jury selection. The court then says, all right. Ms. Comey responds, Your Honor, I don't think that's right. In the first 28, Ms. Shapiro then says, in the first 28. That's the court then says, that's what Comey interjects and says, I don't think that's right. And if I can correct the record, juror number 184, who is on the jury, I believe, is a black man. The court then says, well, I think we have the government's response. Ms. Comey, do you have anything further in response to Ms. Shapiro's submission? Ms. Cody says, Your Honor, I would want the record to also reflect that there were other men who weren't non-white men also seated on the jury. I think I note that, but given, Ms. Shapiro interjects, I don't think that's correct. But then the court interjects and says, all right, I understand that you've got supplement the record. Ms. Comey has responded, and the Batson application continues to be denied. Okay. So let me go back a little bit to that because I remember, see if we can find something quick on that. Okay. So the Batson challenge refers to the act of objecting to the validity of a preemptory challenge on grounds that the other party used it to exclude potential jurors based on race, ethnicity, or sex. The results of a successful Batson challenge differs, but generally it may be a new trial. Okay, so judge is saying no on that, completely denied. Okay, all right. Hold up. So the judge says Ms. Comey has responded and the Batson application continues to be denied. So with that, at this point, Mr. Courtroom Deputy, are we prepared to bring in the jury? The deputy clerk responds, yes, Your Honor. The court then says, all right, let's bring in the jury. Okay, so jury's directed to be seated. The deputy clerk says, Your Honor, I'll confirm that I have the jurors seated in the correct position. Are you juror number 2? Juror number 2 answers yes. Are you juror number 5? Yes. Are you juror number 25? Yes. Are you juror number 55? Yes. Are you juror number 58? Yes. Are you juror number 75? Yes. Are you juror number 116? Yes. Oh, excuse me. There's no yes there, but the clerk says thank you. Okay. Are you juror number 160? Yes. Are you juror number 184? No response. Are you juror number 201? Correct. Are you juror number 217? Yes. Okay, proceeding to the last row. Are you juror number 230? Yes. Are you juror number 234? Yes. Are you juror number 292? That is why we do this. Are you juror number 292? Yes. Something happened there and they had to be told that, are you this juror? The deputy clerk says, great, thank you. Are you juror number 321? Yes. Are you juror number 330? Yes. Thank you, Your Honor. Okay. Court starts. Good morning. Good morning, ladies and gentlemen, and thank you for bearing with us through the jury selection process. Welcome back to the United States District Court of the Southern District of New York. As you were told when you were here for jury selection, I am Aram Samaranian, and I will be presiding over the trial in this case. United States of America versus Sean Combs. Trial will begin shortly with opening statements. We will sit every weekday until trial is over, with the exception of court holidays. Our anticipated schedule had not changed since I last spoke to you. The attorneys and I expect this trial to be over before July 4th. Obviously, it is possible that the trial could go longer, but I don't expect that it will. Every day this week, we will be here from 9:30 a.m. to 5 p.m. After this week, we will go from 9 a.m. to 3 p.m. each day, and we will try to make your trial experience as smooth and pleasant and as possible. There's a typo there. If any issues come up, please contact the courtroom deputy. A light breakfast will be available for every trial day in the jury room at 8:30. And I encourage you to arrive early so as to not delay the other jurors and participants in this trial. We will take a shorter than usual break for lunch. I'm anticipating about 30 minutes, but we will have lunch provided for you in the jury room, so you don't need to leave the courthouse and take the additional time. Now, the reason why we will have one shorter break in the middle of the day is so that you can leave earlier most days. That is the point. So that you can have more time to attend to the things you need to do in life while we're conducting the trial. Of course, if you need a break during the proceedings of any urgent personal reasons, you should let the courtroom deputy know. But I will make every effort to move this trial along promptly and make efficient use of your time. Now, the names and identities of the jurors are known to the court and both parties, who will keep your names and identities in confidence. In order to protect your privacy, that personal information about you will not be disclosed to the public. This is in no way unusual. It is a common practice followed in many cases in the federal court that is being followed here in this case. The courtroom deputy will now swear in the jury. Is there anyone in the jury who does not swear on an oath but affirm? Put your hands down for a minute. Is there anyone who does not take an oath? You can raise your hands again. A jury of 12 jurors and 6 alternates were impaneled and sworn. All right. All right, how we doing? How we doing? Okay. No worries. You got time to catch up. We got some time, okay? Shout out to everybody that's here. Okay. Here we go. The court says, now, members of the jury, now that you have been sworn, I will give you some preliminary instructions to guide you in your participation in this trial. To begin with, you are here to administer justice in this case according to the law and evidence. You are to perform this task with complete fairness and impartiality and without bias, prejudice, or sympathy for or against any of the parties. It will be your duty to find from the evidence what the facts are. You and you alone will be the judges of the facts. You will then have to apply those facts to the law as the court will give it to you. You must follow the law whether you agree with it or not. Nothing that I say or do during the trial is intended to indicate or should be taken by you as an indicating that your verdict should be. The evidence from which you will find the facts will consist of testimony of witnesses, documents, and other things received into the records as exhibits, as well as any facts that the parties agree to or stipulate to that the court may instruct you to find. Certain things are not evidence and must not be considered by you. I will list them for you now. First, statements, arguments, and questions by lawyers are not evidence, nor are my own statements to you. Only the answers given by the witnesses and the documents admitted as exhibits are evidence. Okay. Second, objections to questions are not evidence. The lawyers have an obligation to their clients to make an objection when they believe evidence being offered is improper under the rules of evidence. You should not be influenced by the court's ruling on an objection. And if the objection is sustained, ignore the question. If it is ruled, treat the answer like any other. If you're instructed that some items of evidence is received for a limited purpose only, you must follow that instruction. Third, testimony that the court has excluded or told you to disregard is not evidence and may not be considered. Finally, anything you may have seen or heard outside of the courtroom is not evidence and must be disregarded. You are to decide the case solely on the evidence presented here in this courtroom. When you are determining the facts, keep in mind that there are two kinds of evidence: direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness, Circumstantial evidence is proof of facts from which you may infer or conclude that are other facts exist. The word infer or expression to draw an inference means to find that a fact exists from proof of another fact. An inference is to be drawn only if it is logical and reasonable to do so, not by speculation or guesswork. In deciding whether to draw an inference, you must look at and consider all the facts in light of reason, common sense, and experience. Whether a given inference is or is not to be drawn is entirely a matter for you, the jury, to decide. Circumstantial evidence does not necessarily prove less than direct evidence, nor does it necessarily prove more. Here's an example to help you think about the differences between direct and circumstantial evidence. Assume that when you came into the courthouse this morning, the sun was shining as it is outside, and it was a nice day outdoors. Also, assume that the courtroom blinds were drawn and you could not look outside. Assume further that as you're sitting here, someone walked in with an umbrella that was dripping wet. And then a few moments later, someone else walked in with a raincoat that was also dripping wet. Now, because you could not look outside the courtroom, you couldn't see whether it was raining. And because no witnesses has testified that it is raining, you would have no direct evidence of the fact that it was raining. But on the combination of facts that I have asked you to assume, it would be reasonable and logical for you to conclude that it was, in fact, raining. That is all there is to circumstantial evidence. Ooh, wee. Damn. Thank you, Sylvia. Please hit that like button. Where are we at with the likes? Let me see. Hold on. Let me double check on those likes, please, and thank you. 121 likes. How many people we got here? 180. Can we get like an additional, I don't know, 40 likes, please, and thank you? I appreciate it. This is, I feel like I've heard this type, like I said, I did jury duty before, so I've heard this explanation. This is why I'm sorry. I know y'all think that court is crazy. I love court. Court is fascinating to me. But anyways, let's keep going. You infer on the basis of reason and experience and common sense for one established fact, the existence or non-existence of some other facts. I'll give you further instructions on here, as well as other matters at the end of the case, but keep in mind that you may consider both kinds of evidence. Now, one of your most important tasks as jurors is to evaluate the credibility of a witness. Evaluate the credibility of the witnesses who will testify before you. This is how truthful and believable they are. Listen carefully as each witness testifies during both direct and cross-examination, and consider whether the witness is telling the truth. It will be up to you to decide which witness to believe, which witnesses not to believe, and how much of any witness testimony to accept or reject. Now, how do you decide what to believe and what not to believe? You are to listen to the witnesses and observe their testimony, and then decide as you would decide such questions in your life. Did they know what they were talking about? Were they candid, honest, open, and truthful? Did they have a reason to falsify, exaggerate, or distort their testimony? Sometimes it is not what a witness says, but how he or she says it that may give you a clue as to whether or not to accept that witness's versions of an incident or an event as credible or believable. In short, the way a witness testifies may play an important part in your reaching a judgment as to whether or not you can accept the witness testimony as reliable. You may hear from law enforcement officials in this case. The fact that a witness may be employed as a law enforcement official does not mean that his or her testimony is deserving of greater or lesser weight than that of an ordinary witness. You may also hear from two witnesses testifying using pseudonyms, that is, not using their real names. The government, the defense, the court, and you, the jury, will know their real names. But the names will not be used in open court solely to protect the privacy of these individuals from disclosures to persons who are not party to this case. The fact that a witness is testifying using a pseudonym does not mean that his or her testimony is deserving of greater or lesser weight than that of any other witness. Now, a few words about your conduct as jurors. I gave each of you the following instructions when you were here for jury selection last week, but I will repeat the instructions now because they are extremely important and I'm counting on each and every one of you to follow them. First, during the trial, you are not to discuss the case with anyone, nor are you to permit anyone to discuss it with you. This includes posting anything on the internet about this case, whether it be on Instagram, Facebook, X, or any social media platform or website. Until you retire to the jury room and at the end of the case to deliberate, you simply are not to talk about this case with anyone, including your spouse or partner, family, or close friend. Do not even discuss the case with each other until you begin your actual deliberations at the end of the trial. Second, please do not, while you're serving as jurors in this trial, have any conversations with the parties, the attorneys, or any witnesses in this case, whether in the courtroom, in the hallways, in the elevators, outside, and anywhere else. I mean, not only to avoid talking about the case, do not talk at all, even to say good morning or to acknowledge any of these people. Can't say good morning or hello or anything. Don't. Okay? This people are aware, okay? Yes. Oh my God. Nancy Johns, thank you so much for the $9.99. Appreciate your hard work to bring us to court the information. I'm going to go to bed as soon as I'm done here. I'm just letting y'all know, okay? Sylvia, don't get kicked out of court now, my friend. Don't get kicked out of court. Thank you. Nancy Johns, thank you. I appreciate it. Sylvia's like, hurry up, judge. The judge has to say all this. Yeah, you don't talk about the Fight Club. You don't. Oh my God, Abraham, thank you again. Shout out to Abraham as well, y'all. Abraham, many of you guys made it happen today. Thank you. Okay, let's keep going. Y'all are crazy in this chat. I can't even look at the chat. I gotta read the script. All right. Okay. Don't acknowledge the people. Someone seeing a juror in conversation with a party, lawyer, or witness might think that something improper was being discussed. To avoid even the appearance of impropriety, avoid any such contact or conversation. I can tell you that when the parties, witnesses, and lawyers pass you in the halls without even acknowledging your presence, they do not mean to be rude. They're simply following my orders because I have ordered them not to talk to you. All right. Now, we get on that different print here. The court further continues, or the judge. Now, third, do not read or listen to anything outside the courtroom that relates to this case in any way. You are not allowed, you are not to allow anyone to speak to you about this case. If you are approached by anyone to speak about it, politely but firmly tell them that the judge has directed you not to do so, because I'm ordering you not to do so. If any person seeks to contact you about this case, you are required to report the incident promptly to me by sending me a note through my courtroom deputy or through the jury office. Also, be sure that I am informed if any person that you know comes into the courtroom. This is a public trial, so it could happen. But it is important that you do not hear. Wait. But it is important that you do not hear from them what may have happened in the courtroom while the jury was not present. Okay. If you should see a friend or a relative come into the courtroom, please send them a note through the deputy at your first opportunity. Fourth, do not try to do any research or make any independent investigation about the case or the issues brought up by this court. Do not go on the internet tonight and research any matters related to this case. Do not call up lawyer friends and ask them about the type of matters at issue here. Fifth, I know many of you use cell phones, laptops, social media, the internet, and other tools of technology. You all do. You must not use these tools to communicate electronically with anyone about the case. This includes your family and friends. You may not communicate with anyone about the case on technology devices, including through email, text messaging, or any social media sites, websites. And finally, do not form any opinion until all the evidence is in. A case can only be presented step by step, witness by witness, until all the evidence is before you. Keep an open mind until you start your deliberations at the end of this case. Now, you are permitted to take notes during this trial. The court deputy has given each of you a notepad and a pen. Please write your name on the or your juror number, on the cover of the pad. Do not write your name, just the number. If you do take notes, please do so only on these pads. Remember that any notes you take are for your use only, and they are to be used only as an aid to your memory. Your memory controls. If you do not take notes, be careful not to get so involved in taking notes that you are not listening to the evidence. Once you are in your deliberations, if there is a disagreement between one juror's notes and another juror's notes, or between one juror's notes and another juror's recollection, you can ask to have the court reporter read back the testimony or to have that portion of the transcript sent to you, for it is the official court transcript that controls, not any particular juror's notes. During the course of the trial, exhibits will be received into evidence. They will be marked by an exhibit number. If there's an exhibit that you are interested in seeing during your deliberations, or you think you might be interested, just write down the exhibit number at the end of the trial. As you begin your deliberations, we will provide each of you with a list of all the witnesses who testified, as well as a list of all the exhibits that have been received into evidence. This will be a lengthy trial with many exhibits and witnesses, but please do not hesitate to request as much material as you will need when you are in your deliberations. We will now begin the trial. Oof, about time. About time. Repeat after me. All right, let's do this all over again. My goodness. Did y'all hit the like button, please and thank you? Okay, I got a couple minutes. We're going to try our best to get as much as we can, okay? We will now begin the trial. As I told you earlier, the trial is expected to be done in 8 weeks. This week, we will begin each day at 9:30. Please be on time. To help ensure we start on time, please be in the jury room at 9:15 a.m. at the latest so that we can begin without delaying. Starting next week, when we begin at 9 a.m. each day, I will ask you to be here in the morning by 8:45. The key thing is that nobody is late. If any of you are late, we will have to wait, and we can't start until you're all here. And all of us will just have to be kind of cooling our heels until you arrive. And if we lose 10 to 20 minutes each day, we might not be able to get completed on time. It might go past July 4th, which nobody wants. Now, let me tell you how the trial will proceed. Oh man, here we go. Like, can we get to opening statements already? Let me tell you how the trial will proceed. First, we will have opening statements. An attorney for the government will make an opening statement. Then an attorney for the defense will do so. The opening statements are neither evidence nor arguments. They're simply outlines of what the attorneys believe the evidence will show, and they are given to help you follow the evidence as it is presented. After opening the statements, the government will present its case. The government will call its witnesses, and after each witness testifies, the defense will have an opportunity to examine the witness. If that witness is also one of the witnesses the defense will call, that defendant may also examine that witness on matters relevant to its defense so that the witness does not have to testify twice. Following the government's case, the government will rest. The defendant will then have an opportunity to present a defense case, should he choose to do so. The defendant here is under no obligation to present a defense. The burden remains at all times on the government to prove the elements of each offense beyond a reasonable doubt. Should the defense present a defense case, any remaining defense witnesses will testify, and the government will have an opportunity to cross examine them. After the evidence is completed and all sides have rested, the attorney will give their summations. This is the opportunity for the lawyers to summarize the evidence and to give their closing arguments. Following the summations, I will give you instructions on the law, and you will then finally retire to deliberate on your verdict. I know this will be a long road, but I want to emphasize that you have a tremendously important task as jurors. It is to determine the facts. You, and not the court, are the sole judges of the facts. The Constitution itself recognizes your unique role in our system of justice, so please pay careful attention to the witnesses, the evidence received at trial, as well as my instructions on the law. I thank you for your commitment to performing this civic duty and recognize the sacrifices that you all have made to be here today. We will now begin with opening statements. Is the government prepared to proceed? Oh my God. Okay, let's go. Let's go, government. All right, let me see if I can just be the government. What's her name? Miss Comey? No, Emily Johnson. That's Emily Johnson. Here we go. Yes, Your Honor. The court says, all right, you may proceed. Miss Johnson. This is Sean Combs. To the public, he was Puff Daddy, or Diddy, a cultural icon, a businessman, larger than life. But there's another side to him, a side that ran a criminal enterprise. During this trial, you're going to hear about 20 years of the defendant's crimes. But he didn't do it alone. He had an inner circle of bodyguards and high-ranking employees who helped him commit crimes and helped him cover them up. Kidnapping, arson, drugs, sex crimes, bribery, and obstruction. These are just some of the crimes that the defendant and his inner circle committed again and again. You're going to hear about all of them during this trial. Let's start now with just one night. The defendant was on the hunt for his girlfriend, a woman named Cassie. For years, the defendant physically abused Cassie. He also sexually exploited her, forcing her to have sex with male escorts while he watched and recorded it. But that night, the defendant learned he had lost control of Cassie. He found out Cassie was seeing another man. Furious, he set out to find Cassie and the other man. But he couldn't do it by himself. So he took his gun and he took his bodyguard, one of his most loyal lieutenants, to wake up one of the defendant's employees in the middle of the night. I'm going to tell you guys something. That's right there, my friend, was a part of the opening statements that was not on the inner city press. Shout out to him. But I remember the gun. I don't remember that he took a bodyguard, one of his loyal lieutenants. Okay. Maybe I must have missed it, but let me know in the chat if it's sounding different. Okay. And Sylvia says, oh my God, do you see me sleeping in my chair? Let's go. Thank you, Sylvia. Thank you for the $4.99. All right, y'all. Y'all are amazing. Okay. Oh man. Here we go. The defendant yelled that he was going to kill the man Cassie was with. He demanded that his employees take him to that man's house. The defendant forced the employee out of her apartment and into an SUV. They drove to the house. The defendant and his bodyguard broke in, but no one was there. The defendant didn't give up. He kept looking for Cassie. When he finally found her, he did what he had done countless times before. He beat her brutally, kicking her in the back and flinging her around like a rag doll. All of that violence wasn't enough, though. The defendant had to make sure he had control over Cassie once again, so he threatened her. The defendant told Cassie that if she that if she defied him again, he would publicly release the videos of her having sex with male escorts that he kept as blackmail. Souvenirs of the most humiliating nights of her life. This was just one night in the defendant's 2 decades of crime. In one night, he and his lieutenant kidnapped an employee, broke into a man's house, and the defendant beat and blackmailed his girlfriend. And as you will learn, this was just the tip of the iceberg. These are not the only crimes the defendant committed. That's not the only time he kidnapped someone. And Cassie is not the only woman he beat or sexually exploited. For 20 years, the defendant, with the help of his trusted inner circle, committed crimes after crimes. That's why we are here today. That's what this case is about. 20 years of crimes is a lot to cover. So first, I'm going to walk you through what the evidence in this case will show. Then I will explain a little bit about the charges. And then I will tell you how the government will prove that the defendant is guilty beyond a reasonable doubt. So what will the evidence show? You'll learn that the defendant was a musician who created an empire. He had a record label. Bad Boy Records, and other businesses that he ran or controlled. Those businesses made the defendant rich, and he used his money and resources from those companies to build his reputation and to feed his every desire. To do that, he relied on the inner circle of people closest to him, like his bodyguard, chiefs of staff, and other high-ranking employees who ran all aspects of his life. Together, the group worked to promote the defendant's power. They carefully cultivated and guarded his reputation, and they worked to get the defendant everything he wanted. He sometimes called himself the king, and he expected to be treated like one. He expected his inner circle to cater to every desire, including his sexual desires. For years, the defendant used his inner circle and his company's resources to sexually exploit multiple women, including women he forced and manipulated into having sex with male escorts, meaning men who the defendant paid to have sex with women while he watched. Now, hold up. Let me stop right here. Let me get a little drink. Tell them, rabbit. Oh my God. All right. No matter what the defendant and his inner circle made sure he got everything he wanted. Many times that involved committing crimes together and then covering up those crimes. Those crimes included violent acts, like when the defendant brought his bodyguard and his gun to kidnap the employee I mentioned earlier. But you'll hear about other violence too, like when the defendant's bodyguards kidnapped the same employee another time, forcing her to sit through days of lie detector tests. Or when the defendant had a man's car set on fire. Or when the defendant dangled a woman over a balcony. You'll see and hear evidence of all of this. The defendant had impossible demands. When his employees failed to meet those demands, the defendant threw things at them, threatened them, hit them, or pressured them to take drugs. He even sexually assaulted one of them. You'll also hear how the defendant uses employees to get the distribution, let me stop. You'll also hear how, hold up, y'all. It gets rough. By the way, for those that are watching the replay, some of this is going to be edited for a separate video. You'll also hear how the defendant used his employees to get and distribute drugs. They delivered those drugs whenever the defendant asked, including so he could give those same drugs to the women he was forcing to have sex with male escorts. He transported those women and those escorts across state lines, even out of the country for those sex acts. And he used his inner circle and the vast of resources of his business empire to help to arrange those trips and make the women available to him. Let me be very clear on this next point. This case is not about a celebrity's private sexual preferences. The evidence will show that the sexual conduct at issue in this case was coercive and criminal because the defendant made women have sex when they did not want to, because he threatened them. He drugged help. There's a typo here, or he meant to say, okay, he drugged help. He lied to them, and he even used violence to make them do it. Okay. A lot of this trial will focus on just two of those women, Cassie, who I talked about earlier, and Jane. Some of the details of what happened to Cassie and to Jane may be hard to hear, but this is what the evidence will show happened. The defendant used lies, drugs, threats, and violence to force and coerce first Cassie and later Jane to have sex with him in front of male escorts. The defendant insisted that sex occur in a very specific, highly orchestrated way. These sexual performances lasted multiple days and they involved multiple escorts. The defendant called these encounters by different names over the years. First, freak-offs. Later, Wild King nights or hotel nights. Week after week, the defendant directed freak-offs in hotels across the country and sometimes out of the country. At times, the defendant had escorts and the women traveled from out of state, so the defendant's staff sometimes organized flights, cars, and hotels. The defendant's businesses paid those expenses. The defendant had particular demands for freak-offs. At his direction, the defendant's staff set up the room in advance with supplies, like his preferred lighting, extra linen, and lubricant. His staff remained on call to refresh the defendant's needed. There's a typo there. His staff remained on call to refresh anything the defendant needed, like cash to pay the escorts or drugs for the women and the defendants. The hotel rooms were dark. The defendant instructed Cassie and Jane how to look, to dress in lingerie, wear tall platform heels, and have manicured white nails. The defendant selected drugs for Cassie and Jane to take, usually MDMA, also known as Molly or ecstasy. Sometimes those drugs made Cassie and Jane sick, but they also made the women more uninhibited and sexually aroused. Ooh-wee. Okay, let's keep going. We're going to try to finish at least the government side. The defendant fed Cassie and Jane drugs throughout the freak-off so that they could stay awake and perform for him for hours and days at a time. Once an escort arrived, the defendant dictated every step of the sexual activity that followed. Sexual activity that followed the same pattern, and he expected the women to enjoy themselves, to appear to while they did it. The defendant masturbated throughout the freak-offs and often video recorded parts of them. Now, I want to tell you more about Cassie and about Jane. Cassie was a 19-year-old model, an aspiring singer with a hit song when she met the defendant in 2006. The defendant was 17 years older than her and the head of his record label. Soon, Cassie was signed to a 10-album deal with that label. The defendant pursued Cassie, and within a year, they were dating. They stayed together on and off until about 2018. During that time, Cassie tried to work on her music and modeling and acting, but the defendant made her turn down many opportunities. Instead, he paid for Cassie's cars, her apartment, and some of her day to day expenses. Although Cassie recorded music constantly, the defendant, the head of her record label, had the final say on the music that she released. It was never, it was never another album. The defendant started abusing Cassie early on. Initially, Cassie fought back, but time and time again, the defendant hit Cassie in the head, threw her to the ground, and kicked her and dragged her by the hair. In 2009, the defendant threw Cassie to the floor of an SUV and stomped repeatedly on her face. To hide her injuries, the defendant forced Cassie to stay in a hotel for the next week. He refused to let her leave, and he had a staff check on her to make sure she stayed put. The defendant also introduced Cassie to freak-offs early on. Soon, the defendant made it to Cassie's job to find and book escorts for freak-offs. Hold up. Soon, the defendant made it Cassie's job to find and book escorts for freak-offs. Freak-offs that were happening as often as once a week for days at a time, meaning that for almost half of every week, Cassie was in a dark hotel room, high and awake for days, performing sex acts that she did not want to do on male escorts. Cassie will tell you how she felt like when she was choking when the defendant made an escort urinate in her mouth, and how she overdosed at a freak off when she still had an open wound on her face from the defendant's most recent assault. The defendant's physical attacks on Cassie happened at freak-offs too. As you will see on the video during this trial, the defendant hit and kicked Cassie in the hallway of an LA hotel, trying to drag her back to the room where they had been with an escort. We'll talk more about that video later. Cassie tried the first freak-off because she loved the defendant and wanted to make him happy. After that, she knew it was not something she wanted to do. But because of the defendant, it became almost everything she did. Because if Cassie didn't do what the defendant wanted, the consequences were severe. Physically, the defendant beat her viciously, exploiting her over even the tiniest slightest, and then beating her to show who was in charge. He beat her when she didn't answer the phone when he called. He beat her when she left a freak off without his permission. He beat her when he thought she took too long in the bathroom. The defendant taught Cassie that defying him could and often would end in violence. And when she tried to run away, he always found her, often with the help of his inner circle. And Cassie's career and livelihood were also in the defendant's hands, something the defendant made clear to Cassie. He told her he could destroy her career by releasing the videos that he recorded from her performing S acts on dozens and dozens of males escorts. So Cassie knew that failing to please the defendant, refusing his demands, had more than just physical consequences. It had the power to ruin her life. The defendant's control, the defendant's violence, and the defendant's threats. That is how the defendant ensured Cassie could not say no to him. So time and again, when the defendant suggested to Cassie that they have a freak off, she knew she had no choice but to agree and went to work setting one up. She texted the escorts, arranged for them to come to hotels, and put on the performances the defendant wanted. Her livelihood and her safety depended on keeping him happy. Cassie's relationships with the defendant was complicated. You will hear her during the trial that both Cassie and the defendant were unfaithful, jealous, and at times angry. But only one of them had power. Only one had control, and that was the defendant. And with that power and with that control, he made Cassie do his biddings in those dark hotel rooms. You'll learn, though, that Cassie was not the only woman the defendant did this to. This was part of the pattern. Now, I want to tell you about Jane. Jane was a single mom who started spending time with the defendant in 2020. The defendant pursued and romanced Jane, who fell in love with him quickly. Jane was not seeing other men, but the defendant was seeing other women at the time. So his relationship with Jane was not at all public. All right, hold up. Ooh. Okay. We're trying to finish up the prosecutor's opening statements, and then I will do a pre-recorded on the defense side. For the first few months, their sex life was just the two of them, and Jane was happy. That was until the defendant introduced Jane to freak-offs. One night, when they had already taken drugs and been having sex for hours, the defendant told Jane about freak-offs. Jane agreed to try one to make the defendant happy. To her surprise, the defendant said that he would make it happen immediately. That very same night, he took her to a hotel where a room was already set up and an escort was on the way. Jane was nervous, and the defendant directed her step by step. Jane thought the first freak-off was a one-time wild night. Jane was wrong. The defendant continued to ask Jane to have freak-offs and promising that if she did, they would spend quality time together. They would go on dates together. They would go on trips. That was what Jane wanted more than anything, a real relationship. So she agreed. She helped plan freak-offs and reached out to escorts, but even though the defendant promised her quality time and trips, he never delivered. Those were just lies he told her to get more nights in dark hotel rooms with escorts. Jane will tell you about those nights in details, how she wanted the escorts to wear condoms, but many times the defendant did not let them. And Jane will tell you about how he had her take drugs to stay awake and aroused for days. Jane tried twice to make it through these nights without drugs. The first time, she broke down and took ecstasy to finish performing for the defendant. The second time, Jane vomited after having sex with one escort. How did the defendant respond? He told her to hurry up and get back into the room where another escort was waiting. Early on, Jane told the defendant that she didn't like freak-offs and that she wanted to be alone with him. She loved him desperately and wanted a real relationship with him. The defendant did not listen. Feeling stuck and sick of the strangers the defendant kept bringing to these hotel rooms, Jane tried to assert herself in small ways. She found two men who performed in pornography, and she invited them to join the freak-offs. That way, Jane could at least choose the other man she was forced to be intimate with. Like he did with Cassie, the defendant eventually took steps to control Jane financially. The defendant wanted Jane's available to meet him at a moment's notice, and he discouraged her from working. Jane's income plummeted. The defendant gave Jane money and then later started paying the rent for the house that she lived with her child. That way, when Jane resisted the freak-offs and told him over and over that she wanted to stop, he had the power to coerce her back into the hotel room. And just as he had with Cassie, the defendant threatened Jane with the videos he recorded of her engaging in sex acts with escorts. But the lies and the drugs and the threats were not the end of it. Even a year ago today, Jane had the worst day of her life. The defendant came to Jane's house for a at-home date night. She and the defendant argued about another woman that the defendant had been seeing. Jane was upset and jealous. She had now spent years in hotel rooms for forced sex while the defendant took his own other girlfriends for dates and trips. Jane hit the defendant and threw things at him. The defendant became enraged, so Jane tried to get away from him and hide. She ran to her bedroom and locked the door. He kicked it open. She ran to her bedroom and locked the door. He kicked it open. Okay, there's a repeat here. Right there. She ran to her closet and locked the door. He kicked it open. She ran to the guest bedroom and locked the door. He kicked it open. She tried to run out the front door, but he grabbed her in a chokehold, lifted her off the ground by her neck, and kicked her to the ground. Later that night, they fought again, and just as he had with Cassie, the defendant viciously attacked Jane. He punched her in the face, kicked her while she was curled up in the ball on the ground, dragged her by her hair and her arm, and slapped Jane's face so hard she fell over. When all of this was over, the defendant still did not let Jane be. Instead, he told Jane, "You're not going to F my night up." The defendant instructed her to put on an outfit and call up an escort for a freak-out. He made Jane cover her black eye and bruising and take an ecstasy pill and perform for the defendant with that escort. Jane followed his instructions. Like with Cassie, the defendant's violence had gotten him what he wanted. Hold up, let me stop right here real quick. Okay, let me see how much I have left of this. When does the oh yeah, I'm gonna have to stop, guys. I hear Baby Bunny over here. Yeah, because this is page, what page is this? This is page 41. Yeah, I'm gonna have to stop right here, y'all. Let me put a little marker here. Oh my God, there was still more. Here it is. Let me write this down. This is where we stopped. All right, and this is page 114. This is pretty good. Well, 246 pages, okay? All right, let me stop right here. So these are the official transcripts for those that are wondering. Yes, we were able to obtain them. We have the official transcripts for the whole week, okay? So I'm going to stop right here. I'm going to cut some of this video and add it to his pre-recorded video. So if you're not like watching the case, you'll be able to get what's going on inside the case because we have the official transcripts. You're not getting it from another reporter. You're getting it from the court reporters in the room. So if there's any in between, like one thing we didn't catch, then now we know Agnifilo had a problem with Cassie being walking in front of the jury pregnant, feeling like she was going to get empathy for that. Okay. So keep that in mind, but I have to stop right here. Guys, let me know what you guys think. I freaking love you guys. Thank you again for those that supported. This is opening statements. This is where we're at. Y'all let me know what you guys think, okay? I got to go because I got to go tend to Baby Bunny. Hit the like button, please, and thank you. Baby K, thank you again for supporting. Nancy, Sylvia, thank you, guys. Shout out to everybody. Oh, my God. Thank you, thank you, thank you. And I got to go. Where did my Venmo go through? I don't know. I'm sorry. I haven't checked. Okay, and then shout out to, I'm not good at that stuff. I'm sorry, y'all. Yes, Didi, it did. Thank you, Didi. I got it. Thank you, thank you. I don't want to say your name, but I got it here. Thank you, thank you, thank you. I appreciate it. And Bridget too, and Carol. Thank you, guys. I appreciate you guys. Y'all don't even know. I forgot to call out everybody. So we're good. Thank you. No, I appreciate you. You don't even know how much guys, we have the transcripts for the whole week. So if you missed the first week, we're going to have videos to make because we have transcripts. And again, shout out to Danny Robertson. Make sure you guys check out her channel because Danny made this happen, y'all. She did. She pulled through. That's our girl. All right. I'll see you guys on the next one. Bye, guys. Bye, bye, bye.